In this lecture, we shall attempt to solve one essay question on natural justice. And the question reads as follows, and I quote, "What would a reasonable litigant think if he gets to hear of matters such as have been alleged in this motion? For example, that there is intimate relationship between his opponents and the judge presiding over their case. There's no doubt that he will, without the slightest hesitation, form the impression that his case would not be given an unbiased hearing." End of quote. Dissenting opinion of Serebour J. in the case of Attorney General Mr. Salah. Discuss. So this is a question on natural justice clearly. Remember, before you begin to solve, you must make sure you understand the question, have a very good introduction, and remember what we always say. You tell the examiner what you are going to say, you say it, and then you tell the examiner what you have said. But it is good, even though not mandatory, in your introduction that you structure your answer into various parts, so that as you are writing, you can be referring to the introduction to even guide you as to what you are supposed to add in that. So, it's a question on natural justice we have been told to discuss. Let's see what we can have for our introduction. This question raises for discussion the principle of natural justice, with specific emphasis on the nemo judex in causa sua, which means that a judge must not be a judge in his own cause. In this essay, I shall explain the nemo dat code non habeas rule and how it has been applied in Ghana. The second part of this essay shall roll out the material facts of Attorney General and Salah and indicate how its ratio relates to the principle of nemo judex in causa sua. More specifically, in this part, I shall indicate how the case of Attorney General and Salah has laid down the tests that has to be satisfied by a person in proving bias of a judge. The third part will interrogate exceptions to the applicability of the principle in Ghana. The fourth and final part shall then conclude the discussion. Now, why do we have an introduction like this? We have an introduction like this because the question is a quote from a particular case. So we must not only demonstrate that we understand the principle in that case, but we must also demonstrate that we know how the case came about that particular principle. And remember, that was even a dissenting opinion, so you must analyze the statement with sufficient clarity to show that we also have control over the case. Then we discuss the principles that the case helps us understand. So in the first part, we shall explain the nemo dat code non habeas rule. Second part, we shall roll out the material facts of Attorney General and Salah, and then indicate how the principle relates to, the ratio relates to the principle of nemo judex in causa sua. Then, more specifically in this part, we shall indicate how the case of Attorney General and Salah has laid down the test that has to be satisfied by a person proving the bias of a judge. Then the third part will then interrogate the exceptions to the applicability of the principle in Ghana. Then the fourth and final part shall then conclude the discussion. So this can be a good structure, and we can begin to write. To start with, the Nemo Judex in quadrature rule explains that a decision maker should not have a relational, pecuniary, or financial interest in the subject matter of disputes, otherwise the action shall be invalidated. Relational interest is where, for instance, the decision maker is a relative of a party to the dispute. Where a pecuniary or financial interest arises, where the decision maker has a monetary claim in the subject matter of the disputes. In any of these situations, the decision maker is compelled under law to do the honorable thing by recusing himself and not participating in the resolution of the disputes. This has been affirmed in the case of Ex parte Agbesi Awosu the first. Remember, it's a legal paper. When you make your statements, you must support them with relevant authority where applicable. So I've in this part tried to explain what you mean by Nemo Judex in quadrature. That you must not have any relational, pecuniary, or financial interest. And if you do have, do the honorable thing by recusing. So I shall proceed. Likewise, a decision maker who has foreknowledge of the facts of the case ought to recuse him or herself so as not to create in the minds of reasonable men that he was biased. This has been affirmed in the case of Kwame versus Quino. What is important to note is that the courts have, in a litany of cases, held that a mere allegation of bias will not suffice, and that the test of bias is a real likelihood of bias and not a mere suspicion. Let's go back to our introduction and see whether we're on track. So in the first part of this essay, we shall explain the Nemo Judex in quadrature rule and how it's been applied in Ghana. The second part of the essay is where we shall interrogate the material facts of that particular case and how they ratio. So let's go back and see whether they're on track. So we are done with the first part over here, explaining what Nemo Judex in quadrature is. Now let's continue with this part. What is important to note is that the courts have in a litany of cases held that a mere allegation of bias will not suffice, and that the test of bias is a real likelihood of bias and not a mere suspicion. In Attorney General versus Salah, Ex parte Baima, Ex parte Agbesi Awosu, the courts held that the test is an objective one and not a subjective one. Let me make this Bible. The test is an objective one and not a subjective one. That is, whether a reasonable person sees with all the facts will conclude that the decision maker is biased. There need not be actual bias, but there must be a real likelihood of bias. In the case of Attorney General in Salah, the court held that the onus of establishing this real likelihood of bias is on the person alleging the bias. So now we are going to the facts of the case, because remember we said that in our second part we shall roll out the material facts and indicate how the ratio relates to the principle of Nemo Judex in causa sua. So we are now about to roll out the facts of Attorney General in Salah, which is the case in our question, the quotes. In Attorney General versus Salah, both Justices Apalu and Sowa were said to have a relational interest in the Salah and Attorney General case. In other words, there was an earlier case as Salah and Attorney General, which now somebody is saying that the judges had a relational interest in some of the people in the case. So in Attorney General and Salah, both Justices Sowa and Apalu were said to have a relational interest in the Salah vs. Attorney General case. Apalu was said to be an intimate friend of Salah. It was alleged that at times Salah would reserve goods for purchase for Apalu, and that the two on several occasions were heard to be speaking in a strange language and in very familiar tone. For Sowa JSC, it was said that his brother-in-law was part of the category of public officers whose appointment had been terminated by the provisions of Section 9(1) of the Transitional Provisions of the 1969 Constitution, and that this notwithstanding, he had on behalf of his in-law and sister spoken to a higher authority to have his in-law reinstated. Let me just give a background that these were the facts that culminated in the Salah and Attorney General case. The court held that a suspicion of bias would not suffice as a real likelihood of bias unless proved by the party alleging the likelihood of bias. Again, the court held that a suspicion of bias would not suffice as a real likelihood of bias unless proved by the party alleging the likelihood of bias. In other words, if you are merely suspecting that the judge is going to be biased, it will not be enough. But what is relevant is that there must be a real likelihood of bias. For the court, the test is an objective one, that is, whether a reasonable observer from the facts of the case would conclude that there was a real likelihood of bias. So you see over here, it is clear that somebody is alleging that some judges had a relational interest with some parties in the case. The court is saying that merely suspecting bias will not be enough. Now what you must prove will have to be a real likelihood of bias. We shall proceed. Within this context, it is important to discuss the case of ex parte Agbesi Awusu, in which case the court held that the test of real likelihood of bias had been met and therefore prohibited a judge from hearing the case. This is because the judge, before whom a contempt application was pending, which related to the rightful person to be president of the Anlo Traditional Council, accepted an invitation to attend a meeting of the Anlo Traditional Council, which was called by one of the interested parties to the suit, who was also claiming to be the acting president of the Anlo Traditional Council. Look at what is happening. The judge that is hearing the matter, and it's a contempt application, and the contempt application is connected to who is supposed to be the rightful person to be president of the Anlo Traditional Council. And then you, the judge, that you are hearing this contempt application that is related to the who is supposed to be the rightful person, then someone invites you to a meeting out of courts where you are supposed to go and discuss issues pertaining to how to resolve this issue. And the judge who is hearing the matter in court, you accepted the invitation to go for this meeting. Now let's continue. Even though the judge left the meeting hall before the proceedings commenced, the Supreme Court, in examining the entire facts of the case, adjudged that a real likelihood of bias had been established and therefore prohibited the judge from hearing the case. And it is good to bring this case over here because in Attorney General in Salah, the court found that there was a mere allegation of bias, there was mere suspicion, there was no real likelihood of bias, so the judges were not removed from the case. So it's good to contrast that with this case of ex parte Agbesi Awusu, in which case the court held that whatever had transpired raises a real likelihood of bias, and therefore the judge ought to be prohibited from hearing the case and given to a different judge. So let's go back to our introduction. In the first part, we said we shall explain the Nemo Judex in Quadrilateral rule and how it's been applied in Ghana. I think we've been able to explain it because we've been able to explain what it means. We've shown how it has been applied in Kwame and Kweno and things like that. Second part shall roll out the material facts of Attorney General Insala and indicate how its issue relates to the principle of Nemo Judex in Quadrilateral. I think we've been able to do that because we've explained the fact how some of the judges were being alleged to have been speaking in a very familiar tone and things like that. But in all of that, what did the court say? That will not be sufficient to prove bias, and that what it must prove has to be a real likelihood of bias and not mere suspicion. So we can conveniently say that we've done with that part as well. We say that more specifically in this part, I shall indicate how the case of Attorney General Insala has laid down the test that has to be satisfied by a person proving bias of a judge. I think we've dealt with that because we mentioned that the person must prove a real likelihood of bias and not mere suspicion. Third part, what did we say? Third part, we shall interrogate the exceptions to the applicability of the principle in Ghana. So now let's go to the third part. Having explained the principle of Nemo Judex in Quadrilateral, it is important to now discuss the exceptions to this rule. Three main exceptions have been identified. The performance of statutory duty, necessity, and acquiescence. Each of these will be briefly looked at. So we are going to look at these three exceptions: performance of statutory duty, necessity, and then acquiescence. So first is where the decision maker is under a statutory duty. The principle is that where a statute or the constitution imposes a duty on the decision maker, then the rule will not apply to compel such decision maker to recuse him or herself. For instance, under the 1992 Constitution, the practice direction of empaneling judges of the Supreme Court is the reserve of the Chief Justice. In that regard, it would be wrong for a litigant to assert that because, for instance, his or her case is against the Chief Justice ought not to empanel the justices, as held in the cases of Akufo-Addo and Kwasi Aidan, Chatu Chikata versus the Chief Justice and Attorney General, as well as Agyechum versus Attorney General. Let me explain this before I read further. If by statute somebody has the responsibility of performing an obligation, the rule is that he must perform that obligation by meeting the requirements of the statute. And that the mere fact that he has alleged bias against him will not prevent him from performing the statutory obligation. In other words, if you have sued the Chief Justice, for example, it doesn't mean that if you sue the Chief Justice, then even though the Constitution gives the Chief Justice the statutory duty to empanel, you will say the CJ cannot empanel. The CJ can still go ahead and empanel. And that's what happened in these cases that I've mentioned. Akufo-Addo and Kwasi Aidan, Chikata versus CJ and Attorney General, and Agyechum. So I shall proceed to read. In the case of Chatu Chikata versus the Chief Justice and Attorney General, the plaintiff instituted an action in the Supreme Court challenging, among others, certain actions taken by the Chief Justice of the Republic of Ghana. The plaintiff, bearing in mind the power of the Chief Justice to empanel the justices of the Supreme Court pursuant to Article 125 Clause 4, objected to the empanelment of the bench by the Chief Justice. The reason for this objection was that the very actions that were being challenged related to the actions taken by the Chief Justice. And as saying the Chief Justice was a party to the action, it would be in breach of the rules of natural justice for a party to the action to decide which persons would preside over the case. I think I understand the basis of this objection. That I have sued you, the Chief Justice, and you are the one going to empanel the judges. Wouldn't you then be empaneling people that you know will come and rule in your favor? That is what animated the view. But the court, in dismissing this objection, reasoned that the power of the Chief Justice to empanel the bench was a constitutional duty conferred by Article 125 Clause 4 of the Constitution. Further, the only time that the Chief Justice is prevented from performing his functions, as spelled out under Article 146 Clause 6, is when it is found that the Chief Justice is unable to perform the functions of his office. On the strength of Article 125 Clause 4, the court therefore held that to the extent that the power to empanel judges was a constitutional duty conferred on the Chief Justice under the Constitution, that right cannot be taken away by relying on the rules of natural justice. Also, on the strength of Article 146 Clause 6, the Supreme Court held that merely alleging that the Chief Justice is biased does not disable the Chief Justice from performing his functions within the context of Article 146 Clause 6. So what has happened so far in the Chachikata versus the AG and CJ case? We have been told that if you have sued the CJ, insofar as the CJ is the one that must perform a statutory duty to empanel, your mere allegation of bias will not take away that power. The CJ will still go ahead to empanel. It is opposite at this point to point out that the decision of the Supreme Court is consistent with its previous decisions and binding precedents in the case of Akufo-Addo versus Kwasi Aidan, in which case it was held that where a statute enjoins a person to perform an act, that person must perform the act even if its performance conflicts with the rules of natural justice. If a CJ is supposed to perform an act of empaneling, he must perform it even if his performance is going to conflict with the rules of natural justice. So we've dealt with the first exception. The second exception is under the circumstances of necessity, where necessity requires the principle of nemo juris in causa sua will be overshadowed, notwithstanding the fact that a judge may have an interest in the case. A classical instance is the case of Bilson versus Apalu. In this case, the plaintiff commenced an action against the Chief Justice Apalu at the Supreme Court, seeking a declaration to quash the judgment of the Court of Appeal sitting at the Supreme Court in the case of Tuffuor and Attorney General. Now, follow the following part carefully. The basis of the action was that, in the estimation of the plaintiff, the 5 judges who constituted the court in the case of Tuffuor and Attorney General did not constitutionally hold nominations to sit in the said suits, since Mr. Apalu, the very person who empaneled the court, did not have the power to do so, and therefore it was wrong for the judges to have accepted the empanelment by the Chief Justice to determine the case. When the case came on for hearing, the plaintiff objected to the composition of the Supreme Court, arguing that 2 of the members should not be allowed to sit because they had also sat as members of the Court of Appeal in the case of Tuffuor and Attorney General. Let me explain what is happening. I have issued a writ to challenge whatever transpired in Tuffuor and Attorney General, that the people who sat in that case ought not to have sat over there. And now that I've issued this fresh writ, the new case that is before the court, 2 of the judges who were in the old case that I'm challenging are also in this new one. So he goes ahead to say that, and that since it was the judgment that was being challenged, it was sin against the rules of natural justice for those 2 judges to be allowed to sit in their own course. You get it? If it's your main judgment that I'm even challenging, why should you come and sit over here? It will be an affront to the rules of natural justice. The court, in dismissing the objection, reasoned that if the objection of the plaintiff is upheld, its effect will be to reduce the total number of justices capable of hearing the matter to 4 justices again, the court in dismissing the objection reasoned that if the objection of the plaintiff is upheld, its effect will be to reduce the total number of judges capable of hearing the matter to 4 justices, which would have been below the required number of 5 justices that can sit as justices to hear a case. In other words, if we uphold the objection, we are not going to even have a bench to even hear any matter. So we continue as follows. In other words, if the objection of the plaintiff is upheld, there will be no enough justices to constitute the bench to hear the case, and therefore there would have been a failure of justice. The Supreme Court therefore adjudged that on the grounds of necessity and in order to prevent a failure of justice, the 2 justices against whom bias had been alleged against were allowed to sit as justices over the matter, even though we are talking about natural justice. So it means that if you are going to apply natural justice and it's going to result in a failure of justice, then it's our responsibility to violate the natural justice, to rather affirm and let justice prevail. Because if we should have upheld it, the people will not even have a bench to even hear the matter. The third and final exception to be discussed, which was also mentioned in the Bilson and Apano case, is acquiescence. The idea is that the principle against bias may be waived by a party if, after being aware of the facts, such a party fails to raise any objection in relation to same. In other words, if you have an objection and you know this judge has the tendency of being biased because of any fact that you know of, you cannot wait for the case to travel for 10 years and last day when it's about to give judgment, you say you have an objection. You must raise the objection timeously as soon as the facts come to your attention. And if you fail to raise it, then you begin to have acquiesced and waived and slept on your right to now object. So we've dealt with the third part now. Let's go back to our introduction. Third part will interrogate the exceptions to the applicability of the principle in Ghana. The fourth and final part shall conclude the discussion. Okay, so you can go to the final part. In conclusion, I have, in the following paragraphs, demonstrated the scope and applicability of the nemo duties in Causa Sua rule, the evidential burden that must be satisfied, the evidential burden that must be satisfied by the person alleging bias, and the exceptions to the concept in Ghana. So what we've done so far in this essay is that we gave an introduction, a strong introduction. We told them what we are about to say. They are about to discuss the nemo duties in Causa Sua rule. We said it by saying what the nemo duties in Causa Sua rule is, showing how it's been applied in a number of cases. We've shown how it's been applied in Salah and Attorney General in Salah. And we also saw how it was applied in Ex parte Agbesia Osun. Then we dealt with the exceptions. 3 exceptions. Statutory duty, as we saw in Chachuchika Dapes, the AG and CJ. Necessity, as we saw in Bilson and Apano. And then acquiescence. This is where we shall draw the curtains for this lecture. Thank you.